Good morning, everyone. Thank you for coming. We are going to be talking about psychotropic medication and foster youth, and I appreciate you being here. You know, this is a topic for me that I feel very passionate about. I'm the supervising attorney in the Guardian Litem program in the 4th Circuit, which is Jacksonville, and I previously was in the 17th Circuit, which is Fort Lauderdale, and I have been with the program for 17 years. And child advocacy is my passion. And this specific topic is really one that I feel strongly about, because there was a time, probably toward the end of the 1990s, maybe the beginning of 2000, where I frequently had volunteers that would come and they would staff cases with me, and I was seeing a pattern that volunteer after volunteer would talk about these horrendous side effects that the children they were representing were experiencing. And the more that I would dig deeper into it, the more that I knew that we had a problem. And the more that I became informed and educated and aware, and there was some great law that passed after that that protects children that are on psychotropic medication. So let me tell you what we're going to do today. We are going to talk about the law as it pertains to dependent children that are in our dependency system, that are being prescribed psychotropic medication, or where the department wants to prescribe psychotropic medication. So we're going to talk about the law on that, because I think that knowledge is power. Lawyer or non-lawyer, it's good to know the law, and it's good to know what we can do within the parameters of that law. So we're going to talk about that. And then what we're going to talk about is your advocacy. We're going to talk about how you use that law to help you advocate for the children that you're representing. Because the law does give us a lot that we can do to advocate for children. So we're going to talk about the law and then talk about advocacy and how you can use that to really represent the children that you've been appointed to. Now, what we're also going to do is give you some strategies, give you some great materials that you're going to get at the end of the presentation. And so that would be for you to take home and for you to put in your toolbox and for you to use after this presentation is over to look back as a resource. Some of the things that we're not going to do is we're not going to talk about specific medication or specific drugs. I'm not a psychiatrist, I'm not a medical doctor, I'm not a pharmacist. So there are materials that you have that are going to give you a breakdown. They're not comprehensive, but it's material for you to look at. So we're not going to talk about, now I'm going to talk about anecdotally some medication just through my experience with working with the children that I've been working with and challenging some of the motions. So we'll talk about that, but we're not going to dig deep into the medication, but I'm going to tell you where to look. I'm going to tell you where you're going to go to inform and get yourself educated on the medication, just like I did. Something else that we're not going to do is talk about our own specific cases. This isn't the forum for that, but I'm hoping that this will spark maybe some questions or maybe some thought in your head, because I'm guessing that either you have a child on your caseload right now that is being prescribed a psychotropic medication, or at some point you did. But if you don't, I can assure you, you will. You will absolutely will. Something else that we're not going to do is we're not going to bash doctors or the Department of Children and Families or caseworkers. We're going to talk about how we're going to utilize the law, to best advocate for children without bashing other people. And then the last thing, and this one's really important to me, is I don't want you leaving here with the impression that the Guardian Litem program is anti-psychotropic medication, because that is simply not the case. It isn't. There are children that absolutely need it. And there are children that without it would be in a very different probably part of their life and their behaviors. But at the same time, I also want you to know that there are things that we can do. There are things that we can do within the system and within the law to help advocate and make sure that the medication you're being prescribed is appropriate, and all the other strategies that we're going to go into. So I don't want you leaving here that this is anti-psychotropic medication. That is definitely not the case at all. Okay, so let's just talk about what are psychotropic medication. Okay, Chapter 39 of the Florida Statutes, specifically 39407, is what governs us about psychotropic medication in the dependency system. And within that statute, there is no definition for psychotropic medication. So what we have to do is look to the effect of the drug, how it's affecting the mood, the behavior. Psychotropic medications change the chemical balance of the brain. They chemically change the brain. And so when we're looking at what's a psychotropic medication, and again, in your material, you're going to see a breakdown of some of the most common psychotropic medications that we see, but you have to look to the purpose of the medication. Now, as we know that the psychotropic medications can affect the child's brain, it can affect their mood, it can affect their behavior, and it's prescribed for many different things, and again, anecdotally we'll talk about those things. They can be prescribed for ADHD, schizophrenia, post-traumatic stress disorder, depression, anxiety, ADHD. I'm sure this is all familiar to you. I'm sure I'm not telling you anything that you don't know. So when you're asking what's a psychotropic medication, you look at what is it doing? Is it doing something to alter the child's mood, the child's behavior? That's psychotropic. Now let's talk about a couple of things where it may sound like psychotropic, because there are some medical conditions where psychotropic medications are prescribed. And one example I'll give you is epilepsy. If a child has epilepsy or a seizure disorder, there are some psychotropic medications that are given to control that. In that instance, it wouldn't be considered psychotropic for purposes of this definition, because in that case, that medication is being given to do what? Control the seizures, right? It's not meant to control the child's behavior or improve their mood, okay? So in that case, that would not be psychotropic for purposes of this definition. Let me also give you a little example about something where typically we wouldn't think of it perhaps as psychotropic, but everybody heard of Benadryl? Tell me what Benadryl is supposed to be used for. Just call it out. Allergies, right? I heard that. Okay. So Benadryl, that's what it's supposed to be for if you look at the label. Correct? But I don't know about you, but I've heard, and it wasn't me, but I've heard some people say, whew, I've got to get some sleep. Little Joey's not sleeping at night. I'm going to put a little extra special juicy juice in the sippy cup. Right? Come on, you guys have heard this, right? Yeah. Okay, because Benadryl also does what? Sleepy. So in that case, Benadryl was being used psychotropically. That is not what it's supposed to be used for. But just to give you an idea, because again, it goes to the cause. It goes to what is it doing to the child. I don't recommend we use Benadryl for those purposes, but it absolutely happens. And so in that case, you can say that was psychotropic. Okay, let's talk about just the numbers, because they're staggering. 20 to 39% of children in foster care are taking psychotropic medication. That is 4 to 8 times more likely than children who are not in the system, non-foster children. So it's really important. You know, we're not having you here, we're not doing this because, oh, there's just a few children. No, it's staggering. The numbers are almost incomprehensible when you think about it. And we could probably debate this. We could probably talk about the reasons why we think children in the system are prescribed this much more psychotropic medication than children that aren't in the system. You know, one, we can just start with, as we know, children who are in the system have been, what? Abused, abandoned, or neglected. So is anyone surprised that the children come into the system with all of these issues? Really? Not at all. So there is some reasons, but there's other reasons for that as well. And, you know, like I said, we could debate it. You may have your own personal feelings about why we think this, but the numbers speak volumes to me. And so this is why your advocacy is so important, because it is a big deal, because there are a lot of children that are affected by it. And so we are happy that you are here to learn about what we can do to make sure that we are protecting these children. Fortunately, the legislature, the Department of Children and Families, the Guardian Litem program, we have some amazing rules, regulations, We have law that's very protective for children that are being prescribed psychotropic medication. And so that's what we're going to talk about. We're going to talk about, again, how we're going to use that to our benefit. But for me, what is most encouraging is that the fact that our legislature and the fact that the Department of Children and Families, with their operating procedures and the administrative code and everything that we have, recognize how important this is, which is why we have all of these wonderful rules and statutes that we have that protects children that we're going to definitely talk about. This also, for me, and I want you to know, it gives me hope and encouragement that there is something we can do. You can do something. When I give this training to other staff or to our volunteers, typically I'm met with, Christine, come on. It's a doctor who's prescribing this medication. How can we really challenge a doctor, right? And some of you may be thinking the same thing. I know judges that say the same thing. You know, I've got a doctor that's saying that it's okay and everything else. But guess what, guys? The law tells us that we can do something. We don't just have to take the doctor's medical report, the doctor's diagnosis, the doctor's prescription, and just be done with it. We absolutely can do something, and I'm going to tell you how the rules and the law help us be able to do that. Okay. Now, obviously, with any medication, there's positives and there's negatives. I mean, who here hasn't been to the doctor or has been to the doctor with a loved one or a child and had a doctor prescribe a medication, right? And what are some of the things that you, as a patient or as the loved one of the patient being prescribed, you want to know about this, right? You're going to ask some questions. You want to find out what's the benefits here, what are the side effects. So with psychotropic medication, like all other medication, positives and negatives. We know that psychotropic medication can be very effective in the treatment of depression and anxiety and the symptoms of post-traumatic stress disorder and ADHD. We know this, absolutely. But on the other hand, we also know, and this is where our advocacy comes in, is that there can be some really dangerous side effects. And again, these were things that I heard from the volunteers a long time ago that got me so interested in this topic, when they would tell me that they would go to visit their child and the child was literally unable to keep their eyes open because they were so lethargic and they were so tired from the medication. Or another one that would tell me that they would go to visit the child and the child sat there with this blank stare and actually was drooling. They were so unable to just keep focus, maintain. So we also know that there's loss of appetite. We know that there can be some behavioral issues. Again, positives and negatives to all medication, and that's where our advocacy comes in, and we're going to talk about that in just a little bit. Here's another one that I definitely want to mention, because as you start to dig deep and as you start to learn about the psychotropic medication that perhaps one of the children you're representing is being prescribed, you're going to find a couple of things that may disturb you. One of them is that most psychotropic medications have not been approved by the FDA for children under the age of 18. Okay? But you also don't want to use that as your argument. I can tell you, just as recently as a couple of weeks ago in my courtroom in Jacksonville, someone was trying to, it wasn't us, but someone else was trying to object to the psychotropic medication and said, well, Judge, it's not been approved for children under the age of 18. And he was disgusted by that, and he said, clearly, you're not very familiar with this area because almost all this medication is not approved by the FDA for children under the age of 18. It doesn't mean it's not safe, but what it means is that the FDA can only do clinical testing on adults. We don't use children as guinea pigs, or at least the FDA doesn't. So that's why we don't have those clinical tests, and that's why we have this medication that hasn't been approved, but through experience and through the doctor knowing and doing their own, so to speak, clinical trials, they know that this medication is okay to use in children. However, again, we want to make sure that we're staying on top of that and we're looking into that. The other thing I want to warn you about, and this one is a huge concern to me, is that a lot of the psychotropic medication that our children are being prescribed come with black box warning labels. Anybody heard of that term? Yes, I'm seeing some head shaking. A black box warning label is the strongest warning the FDA requires. Okay, it's a big deal. It's reserved for prescription drugs that pose a significant risk of serious or life-threatening adverse effects based on medical studies. I don't know about you guys, but that scares me. You are going to have a psychotropic medication being prescribed, no doubt, to a child that comes with a black box warning. But what does that mean? And we're going to talk about that in our advocacy, is that we have to make sure that we are staying on top of that case and ensuring that that child is not displaying the side effects that are the reason that we have the black box warning label. Because some of them, they're being prescribed for depression, they're being prescribed for perhaps anxiety, and the black box warning label is, it causes suicidal ideations. The very thing that we're hoping to prevent, the very thing we're hoping to treat, that is one of the side effects. So that should really raise all of our awareness about the medication, especially when it comes with a black box warning. Oh boy. Sorry. Okay, there we go. Ooh. No. There it is. Okay. This right now, as of June 4th of 2015, is the number of children in the state of Florida who are being prescribed psychotropic medication. 2,506 children. So as I said, if you don't have a child on a psychotropic medication right now, you will. It'll happen. Because this number, and let me just break it down for you just a little bit more, because this one scares me. Out of the 2,506 children, 146 children ages 0 to 5 are on medication. 0 to 5, psychotropic, that alters the chemicals in their brain. Anybody else concerned about that? Because I'm going to tell you, right now, there's no long-term studies that show what these psychotropic medications do to children whose brains are still developing. This is a problem. I'm not saying they don't need it. I don't know about the 146 children that are on that medication, but I certainly hope that every one of them have an advocate. I certainly hope that there is one of you on these children. 1,206 of these children, ages 6 to 12, are on this. Still developing brains. And then 1,154, ages 13 to 17, are on psychotropic medication. That gives us our number. I'm sure if we check today, maybe the number's been bumped up, because it seems to be, it ebbs and it flows. We have an increase, then it goes down, something terrible happens, and then everybody gets scared. But right now, that's a lot of children on psychotropic medication. So our advocacy is crucial. And by the way, for anybody that knows a little something about child development or brain development, in children, the brain, the frontal lobe, is still developing until about the age 22, 23. So even then, even when they get to the age of 17, their brain is still developing, and we still don't know what that medication is doing to them long term. I know this slide looks ominous, right? Ooh, cue the scary music. This looks like something out of The Shining. But really, what would happen if you didn't take the time to question it, to investigate it, to challenge it? And that's what we're asking you to do today. That's what we're hopefully giving you the tools to be able to do. To question, to challenge, to check the facts. I just want to quickly share with you, and we're not going to talk a lot about it because this is all a matter of public record. Does anybody remember from 2009 the case of the 7-year-old little boy named Gabriel Myers? Some heads are shaking. Yes. Perhaps if you're not familiar, again, you can look this up. And I'm not going to go through the details of this, but that's the case that really sparked the department and the state to take a closer look at psychotropic medication. In 2009, Gabriel was 7, the history that you can imagine, like most of our children come in with: abusive mom, removed from her care, placed in foster care, was sexually abused, placement, breakdowns, bounced around. There really wasn't anybody that kind of was looking out for Gabriel. And he was prescribed, because they needed to control him, because he kept blowing his placements, and he was prescribed a cocktail of medication. And again, there was nobody questioning, there was nobody challenging it, nobody investigating it. And at the age of 7, in March of 2009, Gabriel Myers hung himself in the foster home with one of those removable showers, the shower things. 7. Because the psychotropic medication he was taking, by the way, came with a black box warning label. No one challenged that. That was senseless. And Gabriel Myers, that's the psychotropic medication. I don't even know what you would call it. That's the motivation that we should all keep in our minds. I'm not saying this to be, ooh, it's scary and everything else. This is real. It's real, and these medications are serious, and we have to take it seriously. So Gabriel Myers, I read through it again last night just to refresh my memory, not that I'm ever going to forget it, because that's the reason we fight. That's the reason we have to question it. I'm going to just give you a quick example of a case, anecdotally, that was actually mine in Fort Lauderdale. One of the other reasons to question, to investigate, to challenge. So I had a 13-year-old little boy, we'll call him Bobby, and we had a motion that came through to administer psychotropic medication to Bobby. And so immediately I'm calling the volunteer on the case and talking to the child advocacy manager, and as a team, we're trying to figure out, is this something that's legitimate? Should we be challenging this? I'm getting facts. I'm trying to figure out, is this the right thing for this child? But the more that I dug, and the more that I found out from the volunteer, the more that I started to really question whether or not this was something that we should agree to. So Bobby, 13, was in a group home. He was the smallest and the youngest boy in this group home. And what I learned is that the other boys picked on him. And they came into his room at night, and they would threaten him. And when they would go on outings, they would bully him. So these are all the things that were happening. And Bobby shared that with his volunteer advocate, who then shared it with me. And so the more that we looked into this, well, by the way, the reason that Bobby was being prescribed psychotropic medication was because he was diagnosed with paranoia. Really? And so I objected, and we actually had a hearing, the doctor testified, and when I started asking the doctor questions about, doctor, are you aware that Bobby's the smallest one in his group home? No, I didn't know that. Are you aware that he's the youngest? Didn't know that. Now, if I told you that Bobby has boys coming in to his room at night, would that perhaps change your impression that he's paranoid? On and on and on. It was the first time and the only time actually that's ever happened. I had the doctor literally withdraw his recommendation for that medication while on the witness stand. He knew none of this stuff. None of that information had been provided to him. Bobby wasn't paranoid. He wasn't having hallucinations. He really was scared. Boys were really coming into his room at night. They really were threatening him. They scared him. He was being bullied. If we hadn't questioned, if we hadn't challenged, if I hadn't gotten the facts on that, Bobby would have been taking a psychotropic medication for something he didn't even have. That's the reason. That's the reason we question. That's the reason we challenge. Okay, so we kind of set that up, laid the foundation. We're going to talk about the statutory framework that we're working under, the law that governs us on this. And so 39407, as I originally stated, that's the law under dependency that governs us for psychotropic medication. But there's also another statute, and we're going to talk about that, which is 39.01305. And that is the statute that governs us about an attorney at Litem being appointed for children that have certain special needs. And there's certain enumerated special needs that we're going to quickly talk about, but specifically as it pertains to psychotropic medication. So that's our framework. In your training material that you're going to receive, there's going to be a detailed list of the rules and the laws that I'm referencing, so you're going to have all that. Also, Rule of Juvenile Procedure 8.355 also governs us as it pertains to psychotropic medication and children that are being prescribed it. Okay. So we're going to kind of, first before we get into this, I'm going to talk about something that is important because the rest of the statutory reference doesn't apply if the parents, if their rights are intact, give express and informed consent to the medication. Okay? So let's talk about that for a second. Child's been removed from mom and dad because of abuse, neglect, and abandonment, right? Well, if their rights are still intact, as we know, they still have the right to make decisions for their children, right? Education, mental health, but medication as well. So the parent or the legal guardian whose rights are intact, they have to first, the department and the doctor has to first seek their express and informed consent from mom and dad. Okay, everybody with me on that? Okay, so express and informed consent has to be obtained from the mom and or the dad. Now let's talk about express and informed consent, because I got to tell you, there's some parents, and I'm sure that you're aware of them, that you would maybe question whether in fact that was express and informed consent. Let's talk exactly what express and informed consent means. Okay, because there's a definition. It means voluntarily given in writing by a competent person, that's huge right there, after sufficient explanation and disclosure of information. That is a mouthful. However, just put yourself in the shoes of the parent or if you're the patient. What would you want to know about the medication that you're being prescribed? If you just think about it like that, what would you want the doctor to tell you? What would you want to know before you're going to start taking this medication? So for express and informed consent, you want to know the reason. The parent has to be given the reason the medication is being prescribed. What's the purpose? What are the risks? What are the benefits? What are the side effects? What's the dosage range? What are the alternatives to the medication? What's the approximate length of time that the child's going to be on the medication? And what kind of monitoring is going to be needed on that medication? That is express and informed consent. If all of that happens, and by the way, this also means the doctor has to speak to the parent. It can be by phone. So if you have a parent that has a huge substance abuse issue, wasted, can't even take care of themselves, or let's just say they've been kind of MIA. They've been missing in action for a while. We have those, right? And then we need to get the child on the medication, and people are desperate to get this express and informed consent because we've just got to start the medication. We don't want to go through all this process and this law about having to take it in front of the judge or having someone object to it. So we're just going to slip this piece of paper under mom or dad's nose and say, hey, can you sign right here? Yeah, your child needs some medication. No, it's fine. It's good. Is that express and informed? No. No, no, no. It isn't. Not even close. How about, I have this, I've seen this. Mom or dad, they could be homeless. Now, the Department of Children and Families has an ongoing obligation to seek the parents out for express and informed consent. And we're going to talk about that. It's in their operating procedures and in the administrative code. So they do. And so in seeking out the parents for that express and informed consent, again, mom and dad might be using, they haven't really been around for a while, they have no idea what's going on with their child. None. Or maybe they're homeless and the Department of Children and Families was able to find mom or dad at the bus stop and again, wave this under their nose and have them sign it. Express and informed? Not at all. So what I say to you is this. Express and informed consent, I've just told you the definition, really truly needs to be express and informed. Because if we just have a parent who really doesn't know anything about their child, they haven't been around, they don't really know what's going on, you know they haven't spoken to the doctor, guess what, guys? We can challenge the parent's consent. You can. I've done it before. I've taken it into court and I said, Your Honor, whatever the case may be, mom's still using, her last 5 drug screens have come up positive, we have no idea where she's been for the last 6 or 7 months. Hold on, let's get us to where we need to be. There we go. And so I challenged the express and informed consent, because who is that benefiting? Who are we protecting to make sure that their consent is expressed and informed? The child, exactly. We don't want just mom and dad signing off on a medication. Now, by the way, if we really do have an express and informed consent, let's just say we do, the parents can revoke that at any time. They can revoke their consent. And if that happens, then the rest of the statute that we're going to talk about kicks in. If it truly is expressed and informed, and it's a valid consent, then the rest of the statute that we're going to talk about doesn't apply as far as going to court and everything else that we're getting ready to talk about. But it can be revoked, but what I also want to tell you is it absolutely can be challenged as well. And by the way, one express informed consent isn't a blanket. That doesn't mean you can put the child on every single possible thing that the doctor wants to prescribe. It has to be expressed and informed for every medication. Gotcha? Everybody with me on that one? And if they want to up the dosage, or if they want to change it, again, has to be a new consent, because it's different. That means we've changed it. Somehow there's a change in that, and so you need a new consent for that. Okay. Now, we're going to talk about a couple of the other protective things that we have here, and I mentioned it before. The 39.01305, that's the statute, and it's a beautiful part of the statute that was just passed last year. It came into effect on July 1st, 2014. And so what that is that children with certain special needs, it's a shall, it's a must, be appointed an attorney ad litem to represent them if they fall under certain categories. And one of them, that's the reason why it's in this training, is that if the child is being asked to be prescribed a medication, or the department wants to prescribe a medication, if the child doesn't assent, meaning they don't agree to that medication, then an attorney ad litem is getting appointed to represent that child, to represent the child's express wishes. Okay, as we know, guardian ad litem represents best interest. Attorneys ad litem represent express wishes. Sometimes those two can be different, but oftentimes they're exactly the same. But in this case, when a child saying, I don't agree to take the medication, then it is a must. The statute says an attorney ad litem shall be appointed. Some of the other reasons an attorney ad litem under this section of the statute gets appointed is if the child is being placed in a nursing facility, if the child has a developmental disability, if the child is being considered or is placed in a residential treatment center, which is a locked mental health facility, or if the child is a victim of human trafficking. Okay, so those would be the times under that part of the statute that an attorney ad litem has to be appointed to represent the child. So in our case for this is if the child doesn't agree to psychotropic medication. And the other thing that we were just mentioning is that the guardian ad litem program has its own standards. Here it is. I'm all about the props and the visuals. This is the whole thing right here. But specifically, number 7 in here talks about the appointment of an attorney ad litem and how the guardian ad litem program has to conduct itself when asking for an attorney ad litem, because there are times that we are the one asking. We say to the court, Your Honor, we believe that attorney ad litem is absolutely necessary for the child. But as we know, the department, once they identify that the child meets one of those categories under that statute, they have to ask for the appointment of the attorney ad litem. And just so you know, just so you know the procedure, because we do have some attorneys in here that take those appointments, the way that the statute is written is that once we've identified a child who needs the attorney ad litem appointment, then it comes to the guardian ad litem program. The guardian program is tasked with trying to identify an attorney who's willing to take it pro bono, which means without pay. We have 15 days to do that. If we cannot find an attorney to do that within 15 days, then the court appoints someone from the registry. And the registry is something where there have been attorneys that have registered, and they are the ones that then get appointed for compensation through the statute. And so we are very happy and very thankful the legislature has found that this is so important that a child needs their own attorney for that. So if you're on a case, let's just say you're guardian ad litem, and you have an attorney ad litem, that's the reason. They've been appointed to represent the child who is saying, I don't agree to take this medication. Okay. Now before we kind of dig in to the statute, now this again, of course, is when the parent has not given their express and informed consent. Because they can, but there's also times, and there are two circumstances, where the medication can be given without going through this whole process that we're about to talk about. And they're considered emergency situations, okay? And so the first one is if the prescribing physician certifies in writing that it would cause significant harm to the child if they aren't given the medication immediately. Okay, so that would be one of the first ways. The doctor has to say, in writing, in their medical report, significant harm will come to the child if this medication isn't given immediately. And the second way that a medication can be administered in advance of a court order is if the child is in a hospital, if the child is in a crisis stabilization unit, or in a psychiatric residential treatment center. Okay, that makes sense, right? We can all wrap our head around that one. Think about it. If you're in the hospital or the child's in the hospital, we can't delay the process by waiting for this whole thing to happen. So if the child is in a hospital, for medical reasons, whatever, then they can go ahead and prescribe the medication. If the child is in a crisis stabilization unit, what does that mean? A Baker Act, right? The child's a threat to himself or to somebody else, needs to be stabilized. They can prescribe it there and administer it. And then the other one is if the child's in a residential treatment center, right? Everybody good on that? Those would be considered the times when you don't need to get the court authorization or the parental authorization. It doesn't mean that it just stops there. So if you get a case and you look at it and the child's on a medication and you go, oh, okay, I see that, they were in the hospital. Okay, that's great. But the analysis doesn't stop there. The department still has an obligation to file a motion within 3 working days of that child being given that medication. The process still kicks in, but this allows for the emergency situation. Okay, so if you get a case and you see, okay, child was in an RTC and this medication just followed them, okay, that's right. However, there still needs to be a court order that authorizes the continuation of that medication. Okay? Everybody good on that? I have to just share something with you because I had never heard this. Recently at the Disabilities Summit, there were a couple of young ladies. There was a psychotropic medication workshop that we had. And there were a couple of young ladies who had been former foster youth. And they had had mental health diagnosis after mental health diagnosis, in and out of RTCs, in and out of Baker Acts and crisis stabilization units. And they talked about being administered the psychotropic medication on an emergency basis. And it was, I guess it shouldn't have been shocking to me, but the fact that they now have lingo for it. But if one of them got out of hand and the staff couldn't control them, they talked about how they would get shot with what they called booty juice. Mm-hmm. A shot right in the booty. So the fact that they have this, they knew it. They knew this is what they call it. And so booty juice is what they call the emergency medication when they can't get a child under control. They're getting shot up with something that basically is going to put them to sleep. And then I was also told, which was also even more concerning because, again, psychotropic medication has side effects. There are things about the psychotropic medication that we should be concerned about, right? They're shot with the booty juice and then sent to solitary. So then they're sent to some room by themselves after they've been shot with the booty juice where no one's really monitoring them. I don't know about you, but that concerns me as well. But, So that's why we have to make sure that if they got the booty juice or if they got the emergency medicine, we have to make sure that that process is still happening after that. 3 working days, the department needs to file a motion to continue that medication. Okay, so now we're going to kind of get into the nuts and bolts about the law and the statute. You know, there are times that when children are sheltered, when they come into the system, they're already on medication, right? I mean, a child could have ADHD, there could be, you know, some other diagnosis that the child has had. So if the child comes into the system with the medication, that's okay. The child protective investigator can allow the child to continue to take that medication. Obviously, we want them to. However, there's a few things that need to happen. First of all, the medication needs to be in its original container. So in the pill bottle, if mom and dad have a baggie of pills, and they're like, oh yeah, somewhere in there is the Adderall. No, that's not going to be okay. So we need to have the original container. It needs to be a current prescription. So at the shelter hearing, that's okay. That medication can continue, but we need to make sure original container, current prescription. Obviously, the department needs to check all of that out. And then to continue it, the department needs to be advised by a physician that it's okay to continue with that medication. And all this information needs to be provided to the court. You know, the pertinent information about all of this so that the court can make an informed decision. Now, I know that at that point, basically none of us are on the case, right? We get appointed at the shelter. Our attorneys at Litem, they're probably not going to be appointed until sometime after that. But I'm telling you this because, again, if you get the case at some point soon after shelter and you notice that the child's taking medication, okay, that's fine, but we need to make sure that some of those things have happened. The original container, current prescription, you're going to look into all of that. But even still, because remember, we're staying on top of that, the department still has to file a motion to continue that medication after the child has been taken to the doctor to say that it's okay. And then the rest of the procedure kind of begins. So you could very well see children coming into the system on psychotropic medication. This picture is for me. I so love that. I don't know about you. Do you ever feel like that? Right? Buried. You're like, yeah, I'm there. And that picture really is here for this reason, because I know we feel buried. I know we have a lot on our desks to do. But when one of these motions comes through, the motion to administer psychotropic medication, it's got to get bumped to the top, somewhere here. That all back there, okay, that's important. But that motion has got to go to the top of your list. Time truly is of the essence on these motions, because under the statute, we only have 2 working days. That's what the statute says, working days. I don't know about you, sometimes we're working on the weekends, but I'm thinking they mean business days, but 2 working days to file our objection. So, what that means, from the time you get it, you've only got 2 working days to say, okay, we're okay with this, go ahead and administer it, or no, we have a problem with this. It's a lot to put together. I know, I get it, and we're going to talk about all the things we have to look at, and really you're going to be like, Christine, are you serious? Really? How are we supposed to do all of this? But I'm going to give you some little tips and some little things that we're going to talk about that we can do. But when you first get that motion, attorneys, what you want to do is you want to look at, is the motion legally sufficient? And this is for our lawyers. And so non-lawyers, you don't have to worry about this. This is for our lawyers to do. It is pursuant to statute. The statute is very clear what that motion has to contain. So lawyers, you're going to look at that and make sure, does it contain the things that are statutorily required? Right off the bat. And in addition, attached to that motion is supposed to be the medical report. That is the physician's affidavit that the doctor has to fill out, and it has to be attached to that motion. If either one of those things are deficient, I'm objecting. If it's legally insufficient on its face, there's your objection right there. Okay? So you want to look at the motion, you want to look at the medical report that's attached to it, 2 working days to file, and this is really for all of our circuits that are going to ultimately be doing this, but each circuit should have their own protocol about how they're going to deal with these motions. Something should be in place. How are you going to bump this up on the priority list and make sure that it doesn't fall through the cracks and that we don't ignore one of these motions? Okay. Now the next thing is the hearing. If we object, if we do object, we file our objection within 2 working days, there is going to be a hearing. Pursuant to the statute, there has to be a hearing on that. We're going to get notice of it. The burden of proof is the preponderance of the evidence. Again, this is for our lawyers. So volunteers and non-lawyers, don't get worried about all of this because, again, this is for our lawyers to worry about and getting ready. But the information that our advocates are gathering is crucial to us challenging these things at the hearing. So at this hearing, in addition to the judge taking into consideration the medical report, the motion, and its legal sufficiency, there's also something beautiful in there that talks about best interest. And that is where our advocacy comes in if you're with the Guardian Litem program. And so the judge has to consider the testimony, if there is, has to consider the motion, the medical report, any testimony that's taken. As for lawyers, one thing I want to tell you is that that medical report that's attached to the motion is admissible. The doctor does not need to come and testify. It is admissible. It comes in without the doctor. If you're challenging it and you want the doctor there because you want to cross-examine that doctor, which can be extremely delicious, by the way, if you're challenging it, so you have to subpoena the doctor to be there. Or the court can also ask for the doctor to be present. But if it's the department's motion and we're objecting, don't think the doctor's coming. He or she is not going to be there unless you subpoena him or her. Okay? That medical report comes in. So after considering all of that and the doctor's medical report, perhaps the doctor's testimony, the court is going to decide whether or not there's some things that the judge can do at that point, which we're talking about in a couple more slides ahead, but that's the hearing, okay? Now, if the Guardian Litem is going to testify, if we're objecting to it and there's a best interest, that's the Guardian Litem to do, then the Guardian Litem obviously is going to be prepared for that. The attorney in the office, the child best interest attorney, is going to prepare the Guardian Litem for that testimony if that should happen. Okay. This is the slide that I love. This is where we're preparing. We're digging deep. This is where we're preparing our challenge. These are our advocacy strategies. So we kind of laid the foundation. I gave you a really quick, broad overview about the law, but this is where we are digging in and digging deep as far as what we do. Okay, because remember in the beginning when I said, people say, oh, come on, Christine, it's a doctor. What are we supposed to do? How do we challenge this? Okay, here's what we're going to talk about it. So, as I said, we're going to check the motion. That's the first thing. Check the motion, make sure it's legally sufficient on its face, right? That's a no-brainer. Here's where we really get into this. Check the facts of the case. Like my example with Bobby, when you see the diagnosis, is the child really paranoid? Dig. Have your volunteer advocate or you as the attorney at Litem, if you are challenging this on behalf of the child, you have to get the facts. Talk to the teacher. Talk to the therapist. Talk to the caretakers. And please talk to the child. Talk to the child. Go see the child at school. See how the child is interacting. Because I'm going to tell you, as we know, with mental health issues or with behavioral issues, and it's usually going to be across the board, right? It's going to manifest itself in school. We get lots of reports from the teacher. But I had a case where the behaviors were only happening in the home. No reports. This child had no issues in school. I don't know about you, but that makes me tilt my head, right? Well, guess what? Dig a little bit deeper. There was a problem in the home. There was not a problem with the child. The child was fine. It was the placement. And so rather than the child taking medication to fix the behaviors in the home, I asked for the child to be removed. And by the way, wow, miraculously, all of these behaviors disappeared. So check your facts. Talk to anybody that has anything to do with this child. Dig deep. But most importantly, talk to the child. Here's another thing. What information was provided to the doctor? Anybody have a case where you dig a little bit, you find out that the department or somebody else, so I'm not going to talk about the department, they didn't give the doctor any information. Child walks in based on perhaps the self-reporting of the caretaker, and based on that, the child is given a diagnosis and a medication. What else was the doctor provided? What if the child has a history of a seizure disorder, or has diabetes, or has some other medical condition where the psychotropic medication is contraindicated? How about the child has this history of PTSD? Or how about the child had a traumatic brain injury? That is huge. The doctor should be looking into all of that. Perhaps this is neurological. Perhaps this is something that is an organic brain disorder. All of that information needs to be given to the doctor. Would any of you walk into the doctor and say, I'm not telling you anything, doctor. Diagnose me. Come on, bring it. I'm not giving you anything. But what do you think I need? What do you think? What's wrong with me? But I'm not telling you anything. Seriously, the doctor needs to know everything that we can give him or her about the child. So if we're challenging a medication, or we're trying to figure out if we should agree to it, find out what the doctor was provided, please. You can call the doctor. They're typically very responsive, I find, if you're calling about a medication. So call the doctor and say, what information were you given? Okay, that's huge. Now, as far as the medications, again, I told you in the beginning, I'm not a doctor, I'm not a pharmacist, a psychiatrist, but you know what I can do? I can get on the internet. I have the ability to get on the internet and research. And there are some great websites that I rely on, and it's in your material, that I go to. Drugs.com, for me, beautiful. I even get they send out periodic recalls when a medication's been recalled. Hello, nobody wants to be on one of those. So they will send you out little warnings that a medication's been recalled, or they found, I always love these, where there's particular medication where they found that there was particles in it or something like that. It was been given intravenously to people in the hospital or something. But anyway, drugs.com is awesome. You go on there, you put in the medication, and by the way, what I'm finding is that it's required for the motion for us to know what the side effects are. And every motion that I've ever gotten from the Department of Children and Families in the last probably 4 or 5 years, there's a printout from drugs.com of the side effects, because they are required to put that in their motion. And so they're using drugs.com as well. Here's the other thing that I love about drugs.com, is that almost came out wrong. Here's the thing I love about drugs. No, .com for the video, .com. So the thing is that they have a drug interaction thing. So thing, for lack of a better word. It's on the top, and drug interactions, because what did I say? A lot of our children are being prescribed a cocktail of medication. So if you want to figure out how all these drugs are interacting, you go to drugs.com, you click on the drug interaction, you put in the medication, put in the next one, put in the next one, put in the next one, and then hit enter, and then it all comes up with this beautiful little analysis about how this drug interacts with this drug. Or how about the child's already on a cocktail of medication, and you want to see how is this new one that's being administered, or they're asking to be administered, how is that going to affect it, right? So the interaction is also huge, because you can't presume that someone else has done that. You just can't. You may be the only one that's checking the drug interaction. I hope the doctors are doing that. But again, if they haven't been given full information, such as, the child has some other medical condition that would be contraindicated for this medication, or how about this one? How about, and you know this, There are some medications that you're not supposed to eat certain foods with it. There's some medication that you can't eat grapefruit, right? You guys heard about that? Well, if the caretaker of the child doesn't know that, and they're giving the child something that's contraindicated with the medication, that's a problem, right? So we need to know about that medication. We need to know what the side effects are. We need to know about the interactions. We also need to know, and this is where drugs.com comes in, is the child supposed to be having blood levels checked before going on the medication, and then how frequently after going on the medication? How about, because it's going to tell you, is there supposed to be a baseline EKG? Because some of these medications have very serious cardiac side effects. A baseline EKG is required for some of these medications. And so if that doesn't happen, or that's where you come in, your advocacy. When you say, okay, has a baseline EKG, you will blow people away with your knowledge. When you say, have a baseline EKG, the doctor's going to be like, huh? Yeah, bring it. I know what I'm talking about, EKG. How about blood work, CBC, complete blood, what does that stand for?
Count.
Tell me. CBC? Complete blood count, exactly. CBC. There's also some other things that they have to do. There's neurological testing to make sure that the child isn't having some of the serious side effects that come from psychotropic medication. One was called tardive dyskinesia. You don't even know about this one. This one I just happen to know because I've had some children who have developed this. Tardive dyskinesia is a very, very serious side effect from psychotropic medication. It's where the child develops an involuntary muscle spasm, typically in their face. It is very obvious. There was one time I had a young lady who came to court. She was sitting next to me, and I knew immediately that she had, I just knew, because she didn't even know she was doing it. It's a tic, it's a muscle spasm. They have no control over it. And this, by the way, is sometimes irreversible. So, guys, when you're seeing your children, when you're going out and you're making your visits, look at these things. If you're seeing the child that has a weird tic or any other thing that looks like a possible concerning side effect, make a note. Definitely. We're going to talk about that as far as our advocacy and our continued advocacy, but those are things that are concerning. So, with the medication. Also, again, as far as the diagnosis, does it match the facts? Does the diagnosis that the doctor is giving match the facts that you know? Does it match the child that you know? Does it match the information that you're being given? Does it match up with what you're hearing about how the school is reporting that the child is doing? Or just your own experience with the child? These are all things that you're doing. That is part of your advocacy. That is part of you looking. That's part of you challenging it. Because I'm going to tell you, there are a lot of times that the doctor may get it wrong. But again, it's because they haven't been given full information. Or how many times do you know, could be in a trial, it could be when you're doing one of these and you're challenging it. Doctor, how long did you meet with the child? About 10 minutes. 10 minutes. Anybody have a problem with that? 10, that's how much time was spent. Because by the way, the doctor is also required to discuss the medication with a child who's age appropriate. The child has a right to know what they're being prescribed. So 10 minutes, to me, I wouldn't be comfortable with a doctor that came in and talked to me for 10 minutes and was getting ready to give me a medication that is going to change the chemicals in my brain. I have an issue with that, and I think you would too, as a patient, as a parent, as anyone that you love that's being prescribed one of these medications. Here's another thing for you to check out. When you're looking at this and you're trying to make a decision, should I challenge this? As far as the child, is this a child that has a pattern of running away? Is this a child that you know of that may use drugs when they're on run? Or they're using alcohol? Because if so, red flag, big, big, big fat problem there. And I'll tell you why. If a child has a history of running, or a pattern of running away, or not taking their medication consistently, or we know they're using drugs or alcohol, again, this medication is not the kind of medication that can be stopped and started. Very, very dangerous. It is also not the kind of medication that is going to mix well with some of the substances or with alcohol, especially if the side effect is that it causes extreme drowsiness. Mix that with alcohol, and that is a bad cocktail right there. You have to know your child that you're representing. Because if you do, let's be realistic, we do have children we represent that run away. And if you do have a child that was on medication, that did run away, you want to ask for that child to be checked out immediately when they come back in. Right? Because sometimes they run, then they come back. If they've been on run, you need to advocate for the child to be examined immediately. They need to go to the doctor, because we don't know what they were doing when they were out there, right? Not only do they need to be checked as far as their medication, but STDs, HIV, pregnancy for girls. I know this is not part of this presentation, but it has to do with a child that you're representing that may not stick around all the time. Then the kind of medication that they're asking to put the child on may not be the right one for a child that has that pattern. Okay, that's where you dig. That's where you go in, and that's where you're looking at, is this medication the right thing for this child? Okay, I know I spent a lot on that one, but that's why we're here. This is our advocacy. So in addition to the statute, the Florida Administrative Code has a section specifically focusing on psychotropic medication. The thing that stuck out for me on that, and you all will look through it, it's not actually that many pages, but this one, I gotta tell you, because I looked through this again last night, and this one jumped out at me. In the Administrative Code dealing with psychotropic medication, it says, the administration of medication for the sole purpose of chemical restraint is strictly prohibited. Okay, let me let that sink in. Because there's a reason this is in writing. The administration of medication for the sole purpose of chemical restraint is strictly prohibited. Really? Because I thought that's what we were doing. But I'm going to tell you, in reality, there are absolutely times. There are absolutely times that children, how about that booty juice? That's a chemical restraint right there. That's what that is. Again, I'm not passing judgment, because working in one of those facilities, I'm sure, is very, very challenging. But booty juice is a chemical restraint. There are children that are prescribed medication as a chemical restraint. And I'm going to give you an example, because this is my case. I have a 5-year-old that was removed from mom and dad. As we already know, the removal is traumatic. Okay, we can all agree on that. And so the child was in a foster care placement and was tantruming. The child was tantruming. And the caretaker said, I can't take this. You need to get this child under control, or I'm putting in my 30-day notice for the child to be removed. Now, we know foster care placements are a finite resource, and we try to maintain them, and we try to keep them where they are, because disruptive placements is a problem. I get it, I get it. But again, in this case, it was the caretaker that said, control this child, or the child needs to leave. And so they took the child to the doctor, and of course the doctor was going to prescribe something, and so I vehemently opposed it, because is anyone surprised that a 5-year-old who has been abused by his parents and then removed is tantruming? Really? How about just a 5-year-old in general? They tantrum, or a 2-year-old, or please, look at the facts. Look and make sure that we're not just trying to just keep the child quiet to keep the placement, because that's not fair. It's not fair to the child to have to be put on medication because of a normal childhood behavior. And then, oh, by the way, let's add to it, they've been removed from their parents and the only placement that they've known, right? And now they're going to a new school, and all their friends are back at the old school, and they're living in a stranger's house. Really? That is surprising that the 5-year-old is tantruming? No. So the fact that in the administrative code it says we shouldn't be using it for chemical restraint is telling to me. Because obviously we know that has happened, and they have to put it in writing to say, make sure you don't do it. Okay, so is what stuck out for me in that one. And the other thing for you to know is that the administrative code also talks about the caregiver's responsibility as far as the psychotropic medication and what they're supposed to do. They're supposed to administer it unless the child is of an age and they feel that the child is mature enough to be able to give it to themselves. And it goes through all of that. But what I have to tell you that I found interesting in that part is that it also requires caretakers to keep a medication log. And I'm going to tell you, I've never seen one of those. So as the advocate, please make sure you're asking to see those. And that's going to be part of our continuing advocacy. Please make sure, look to see that this medication log is being kept because they're required to keep it. Another thing that's mentioned in both the administrative code and I'll just flip to the next slide because we're going to talk about this as well. The department has their own operating procedures as it applies to psychotropic medication. This, on the other hand, is quite thick. This is just the chapter. It is 20 pages, the department's operating procedure, whereas the statute that governs it is 3. So there's a lot of things in here that I would encourage you to look at because, again, as advocates for children on psychotropic medication, you want to make sure the department is doing everything that they are required to do. 20 pages. So it basically codifies the statute, but it expands it a little bit as far as their responsibility, as far as the caregiver's responsibility. And so it's important for you to look at that and make sure that they are complying with their own rules, because it's also something that we could do is go into court and say, Your Honor, the department's not even complying with their own rules on this. And here they are, and let me point it out to you. So take a look at that. There will also be, the link will be in your materials. But the medication log was a big one for me, and here's the other one. On the caregiver's responsibility, just by show of hands, and I'm usually shocked by this, who in here has heard or has seen the child resource record? Oh my gosh, that scares me. Wow. Okay. Well, this is exactly what I expected. We're going to spend a little time talking about that because the child resource record is crucial. It is required by the Department of Children and Families to maintain it. Now, maybe I'm calling it by its technical name. Maybe in your circuit it's called the red folder or the blue folder, right? Okay. Whew! I got so scared. Okay, so the red folder, the blue folder, okay. The technical name for that is the Child Resource Record, okay? The Department of Children and Families is required to maintain that Child Resource Record. And contained in that Child Resource Record is all the information about the child. Everything that pertains to the child should be in that Child Resource Record. And where is that resource record supposed to be? At the caregiver, right, where the child is residing. So every time the child moves placement, that resource record is supposed to follow the child. This is huge for us. This is huge in our advocacy because that resource record should be kept up to date. It should have everything in there that has to do with the child, especially the child's medical information and psychotropic medication. That should be up to date. As advocates, as anybody that's representing a child in the system, we need to be asking to look at that. We need to be checking that out and making sure it's up to date. What scares me, because I know it's happened, is that when someone goes to the house and asks the caregiver for it and they have no idea what you're talking about. Wow, I'm scared. That makes me really scared. Because let's just break this down. Ever been to the emergency room? Anybody here ever have to, or go with someone that's been in the emergency room? I'm sure someone in here has, no doubt. When you go to the emergency room, what are they asking you? Besides why you're here.
Medical history.
Medical history, you know, what you have exactly. And how about allergies? Are you allergic to any medication? Right? This all sounds familiar. Let's say you have a child in a foster home, in a relative's home, without the child's information, without all of their information, their background, their allergies, and an emergency happens with the child. They take the child to the emergency room. Again, you are putting the doctor in a terrible position. They do not know, does the child have a history of whatever, fill in the blank? Is the child allergic to penicillin? Is the child allergic to other things that would be contraindicated to the treatment they're going to receive in the emergency room? Right? Problem. If the child resource record isn't up to date, that child is at risk. The caretaker needs to know everything about the child because they're the one tasked with taking care of that child. So in an emergency situation, they need to have that. Well, I want you to leave with a lot of things today, but if this is one thing that sticks out for you, please, 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 please remember, make sure that you are advocating for that child resource record, that blue folder, that red folder to be updated. Please make sure you're looking for it. Please make sure you're asking. Please make sure that our advocates are looking and making sure that's up to date because really, that is a disaster waiting to happen. If you are asking people to take care of a child and they have very limited information about that child that they're taking care of, that is a huge problem. And the medication that the child is taking also, especially if the operating procedures and the administrative code tell us that the caregiver is tasked with giving the child the medication. If they don't even know, if they don't know the side effects, again, you put the caregiver in a very difficult position. So we need to make sure that the child resource record is up to date, that it has everything in it, that the caregiver knows about it. Again, I had a volunteer that went out to go visit a child that was taking taking medication. The child happened to be on a medication, and they went into and the child was 7, by the way, went into the little boy's room, and the little boy on his dresser, and he was on a cocktail of medication, all the medication was lined up on his dresser. I mean, again, I don't know about you. I don't think you have to be an expert in child development or just be a parent about just good caretaking. But again, I was reminded by looking at the operating procedures and the code, caregivers have a responsibility to administer the medication to children. It's supposed to be locked up. It even goes as far as saying that if the medication requires refrigeration, it has to be in a locked box in the refrigerator. So when the volunteer saw all of these pill bottles lined up on the child's dresser, she was really concerned, and with a right to be. And so again, I say to you, you have to make sure that that 7-year-old should not have been left responsible to take care of his own medication. Right? I mean, at 7, what's he thinking about? He can't wait to play Wii or go outside or do whatever. Really, he's going to remember, okay, well, in the morning I'm supposed to take these 2, and in the afternoon this, and then at night No, that is not the child's responsibility unless, again, the child is of a certain age and it has to be discussed with them and they want to administer themselves. But even then, we have to make sure that they are fully aware of what they're supposed to be doing. Okay. So this slide kind of combines a couple of things. And after we talked about the hearing a few slides ago, I told you that the judge has some options about what he or she can do after the hearing or at the close of the case. So after the judge hears testimony, considers the medical report, talks about best interest, takes that into consideration, the court can authorize the administration of the medication. So it can be an authorization, and that's okay. Okay, that's fine. That means we can proceed now with the medication. Or the judge can say, I really think we need to have a second opinion. And that's a really good option. There have been times that I'm challenging it, and I really am not sure about whether this is appropriate or not. I'll ask the court for the second opinion. And so that is something under the statute that the court can actually do. And the thing that I love about this, the legislature, I'm telling you, really takes this very seriously. Because the second opinion, the department has one working day to do a referral for the second opinion. That's unheard of. I mean, the department has to do referrals for certain services and everything else, but in this case, they've been given 1 day to do a referral for a second opinion. So again, that's just kind of showing us that the legislature really takes this very seriously, that we don't have time to wait. So the court can authorize it, the court can order a second opinion. I'm going to tell you, just for me, in Jacksonville, I happen to live by an amazing pediatric facility called Nemours. Nemours is awesome for pediatrics. We are talking about specialists who are at the top of their game. And next to Nemours is Wilson's Children's Hospital. That's where most of my really egregious cases come out of, Wilson's Children's Hospital. That's where they're taken to for really traumatic injuries. So, you know, the department contracts with doctors. Okay, that's fine. But if I have a concern about the medication or about the cocktail of medication that the child is on, I'm asking for a second opinion from Nemours. If you happen to live in a place where you've got a great resource and some really great pediatric specialists, especially in psychiatry or pediatrics or whatever, it's okay. You're not necessarily, I don't want to use the word stuck, shoe not on tape. I didn't mean to say that, but you don't have to just go along with the doctor that the department is contracted with. You can ask for a second opinion from someone you know in the community is a reputable doctor who specializes in this. Like I said, I ask for the specialists in my community because I know they are the best. They are at the top of their game. You can also ask for a consultation, and that's where this comes in, the UF Med Consult line. Just by raise of hands, who has used the Med Consult line? Yay! I'm so glad. Shout out to them. It is awesome. The number is here. So you've used it. You know how good they are. You call them. They will give you a consultation. They will, you know you have to call them, and you give them the child's age, the weight, you give them the dosage, you give them the medication, you give them all that information, and they will set up an appointment with you to call back. Now, guardians are, as far as our team goes, I would recommend you do that as a team. And as our team, it's the attorney, it's the child advocacy manager, and it's the volunteer advocate. Do that as a team. Attorneys at Litem, again, call them, utilize this. It is amazing. And even lawyers, when you're preparing the challenge for the hearing, these doctors are not going to be, they're not going to come in as your expert, so to speak. Let's just say that you're challenging it and you're objecting to the medication. The UF doctors, that's not what they're there for. They're there for a consultation. They're not going to come in as your expert to argue against the department. But what they do, and this is the beautiful part for me, is that they will help you craft your cross-examination questions. Because, again, we're not doctors, and we may not know specifically what to ask the doctor that's asking for the medication, but that doctor will. And you can get that through your question when you call and you just ask some of the questions. And they're excellent. I'm hoping everyone in here that's called has had a positive experience, but they are wonderful. And they will also tell you, I'm fine with that. That medication sounds fine, given what you told me, and given the facts of the case and everything else. So they will definitely tell you, yeah, you're good. And for me, I don't know about you, but that gives me peace of mind because I trust them. They've been contracted and they are specifically set up to do this, and they are experts in that field. So I highly, highly encourage you to take advantage of that because they are experts that are for free that we can use. So those are the different options. Now that last one says discontinuation. I don't like that one. That one scares me. The judge could discontinue the medication. However, it has to be upon a doctor's recommendation because as we talked about before, discontinuing this medication can cause very serious side effects because again, remember, it's altering the chemicals in the brain. So you can't have all of this stuff going in and then all of a sudden it's not there anymore. It could be very problematic for the child. So the doctor has to say that it's not going to cause significant harm. But here's another thing that I want you to be aware of, and I want to just point out because this has absolutely happened. After the tragedy of Gabriel Myers in 2009, what ended up happening is that there were some people that were running scared and realized that they had not complied with all of the laws. and that if anyone was going to start digging deep, because you know they were digging deep, after that happened to him, they were digging, and they were looking in files, and they were saying, do we have court authorization? Do we have informed consent? Is this okay for these children to be on the medication? It was huge, and what they discovered is that a lot of children that were on medication at the time didn't have all those protections in place, so they were getting scared. So what ended up happening, and again, anecdotally, I can tell you because the volunteers would tell me this, is that they knew the child was on medication, and then the next time they went out, after Gabriel Myers committed suicide, is that all of a sudden, the child was no longer on the medication. And so when the volunteer pressed and asked about that, why? And they said, oh, well, we were told that we had to take the child off because we didn't have a consent or court authorization. So what was happening is that they were telling caretakers, just stop giving the child the medication because I don't have anything in my file to back up that it's okay. Ooh, that's a big problem. So discontinuing it is not an option unless, again, you have a doctor that says it's not going to cause significant harm. So we need to be careful with that, too. You know, we may call them out and we may find out, you know, okay, you didn't do what you were supposed to do on this case, but if the child's already been administered the medication, we have to really get a doctor's recommendation about titrating it down. That's really important. And one thing that I'm just remembering that I forgot to mention back in our advocacy slide, but it's important. When I was telling you to look at that medical report, and we're almost done. We're only a few slides away. We're good. How are we doing on time? Excellent. When you're looking at that medical report, the doctor has to fill out certain things on that medical report, and one of them is the dosage, how much the dosage is, or the kind of medication, and what we expect, you know, for the child. When you're looking at that, please pay attention to the dosage range. When you look online, drugs.com will tell you what the typical dosage range is. If you see a dosage range that's, let's say, 1 milligram to 1,000 milligrams, hello, that's a problem. We are not okay with that. Again, look at that, look at the drugs.com and see what the typical dosage range is, because I'm going to tell you why they do that. Because they're giving themselves some wiggle room to be able to titrate it up. But again, our children are not guinea pigs. And that's not, we're not going to be okay with that. If it's a 5 to 20 milligram dosage range, or whatever is acceptable, what's the protocol for that medication, I'm okay with that. But if it's this ginormous dosage range, not acceptable. That's going to be something that we're going to challenge. And here's the other one. On the medical report, it says for the doctor to fill in, how long do you expect the child to have to be on this medication? And so there's the sentence, and then it says for, like, ... with a line. And typically you would see 3 to 6 months, 6 months to 12 months, right? I saw one that literally said, how long do you expect the child to be on this? For ... ever. Forever is what the doctor put in this report. Anybody have a problem with that one? Yeah. So these are the things that we are looking at. And then also, by the way, if the medical report is not legible, I know doctors are notorious for bad handwriting. How are we supposed to advocate if we can't read it? If you can't read what's on there, that's a problem. So you need to make sure that it's legible. Make sure you're looking at all that. Like I said, the dosage range. Forever is never going to be okay. Because by the way, we should never have a psychotropic medication order that's good for more than 1 year. It should be max at 1 year. That's it. If someone tries to put an order in place that says for longer than a year, I'd be objecting to that. Okay, so, you know, we've really discussed the legal framework, we've discussed the rules that apply to this, we've talked about advocacy strategies, what you can do as an advocate, and so this is up here kind of just as a reminder that, you know, you can't just put a Band-Aid on a problem. You know, sometimes these are bigger problems. There was a psychiatrist once that said to me, just as we wouldn't tell somebody that had cancer or diabetes, oh, just get over it. You can't tell a child with a mental health issue, you'll be fine, just get over it. Because it doesn't work like that. And I also don't want to leave you with the impression that if a psychotropic medication is prescribed and you end up agreeing to it, that that's all that the child needs. Because that's also simply not the case. If you ever see a motion or medical report that just says medication without a recommendation for some therapeutic intervention, I'm concerned about that. Because as we know, the children that we represent come to us with a lot of issues. They've suffered a lot. And so we can't fix that with just a Band-Aid and you'll be fine, just get over it. No, that's not acceptable. And so you want to make sure that the other things that should be in place for the child in addition to psychotropic medication is in place, like therapy, like counseling, if it's a younger child, play therapy. There is no medication that is magical and is the quick fix. There just isn't. And so we need to make sure as advocates that we are looking at all of the other things that need to be happening for the child because they're entitled to that. If we've taken them away from their parents because they've been abused, neglected, or abandoned, and now the state is their parent, and we've been tasked with representing them, we have an obligation to make sure they're getting everything that they deserve, everything that they're entitled to, all the services that are going to help them. And so we just don't want you to leave here thinking that psychotropic medication, whether good or bad, or whether it's right for the specific child that you represent, that that's the only thing that they should have. There's other things that they need in addition to that. And we're going to talk about this. And if you happen to represent a child that is a teenager, they have, absolutely, they all have a right, but especially, our teenagers and the youth that we represent, they need to be very much a part of this process. In the materials that you're going to receive, there's a great little pamphlet that you're going to get called Making Healthy Choices. And this is wonderful for you to use when representing teenagers because it's a great guide. It's very user-friendly. It answers questions for youth and gives them guidance. I would highly encourage you to not only look at this, but take it back to your circuit and utilize this and give it to our advocates to hand out to the children that they represent because they absolutely have a right to be heard. They have a right to make healthy choices when it comes to their medication. Obviously, as we know, based on the fact that we have a statute that gives children an attorney who don't assent, they have a right to say no to the medication. And they also have a right to their file. So if you represent a child that's getting ready to age out, at least 90 days before the child turns 18, there should be a staffing on that case. They should be discussing a transition plan. If the child chooses to stay in the system, and that's fine, then they're going to still be entitled to services. But if they choose to turn 18 and leave us and leave the system, we need to make sure they have everything that they need. They are entitled to their file, and especially everything that has to do with their medical report, their history, what they're on. We need to make sure that they know if they want to stay on medication, then they know how to access it, they know how to get it, Medicaid, what doctors that they're going to. But I'm going to tell you that the two young ladies that I referenced earlier, they said that as soon as they turned 18, that was one of the first things they did. They stopped taking all of their psychotropic medication. Of course, I cringed, and one of them even acknowledged that she knew that wasn't the right thing to do. But one of them had reported that she gained something like 175 pounds she took a medication that caused her such weight gain. And they both of them took themselves off of their psychotropic medication. Not that we're advocating for that, but they do have that right. We want to make sure we're giving them all the information to make the best choice. Make sure they have all their information because we don't want them to turn 18, go out, into the world, and then they have an issue that they just simply weren't prepared for. So they do have a lot of say in this, and I just want to make sure that if you are representing a teen, that you know kind of all that they're entitled to, and we give them the information that they need. And just as we we're saying that, as they're getting ready to age out of the system, they are vulnerable. They are very vulnerable because they haven't perhaps had a mentor or, a role model that we would like them to have. Hopefully, as their advocate, you have given them everything that they need and the tools they need to be successful. But, being on medication, being in the system, it really puts them at a disadvantage in some respects. And so we just want to make sure that they have everything that they need, including their file. And, attorneys, that's really for you to advocate for. In your ongoing advocacy, once the child is on the medication, we don't just turn a blind eye and say, okay, that's it. We have a continuing obligation to continue to advocate for the children. So even if the medication is authorized by the court or the parents consent to it, our advocacy is ongoing. We have to continue to ask those questions. We have to continue to see the child and look for those side effects and speak to all of those people that are in the child's life. We have to continue to make sure that the department is doing what they're supposed to do. Every judicial review hearing, when a child is on psychotropic medication, that's supposed to be addressed. Everything that's happened for the child medically is supposed to be attached to the judicial review that the department files. So our advocacy doesn't stop just because the court authorizes the medication. In fact, I would say it should be heightened. Our awareness should be increased at that point. We should be looking and digging, continuing to look and continuing to dig. Maybe the child was put on the medication and we were all okay with it, but now we're seeing really concerning side effects. So that our advocacy continues. It will continue after the medication. You will continue to look and dig and make sure that we are doing everything that we can to represent that child and make sure that they're healthy. And of course, we want them to be stable, and we want to make sure that we're doing everything that we can to protect them. I want to thank you. I want to thank you for being here. I want to thank you for your advocacy. And not to be overly dramatic about this, but I can tell you, because I've been working really closely with children with psychotropic medication. This has been my pet peeve and my issue for a long time. You literally could change. You could, not only are you making a difference, but you could literally be the difference in a child's life. And so I thank you. I thank you for your advocacy, and I thank you for continuing to fight the fight for our children.